So I think that was the essence of that decision, and I think that's pretty much what guides the states too in making their decisions.
Okay, while we're waiting for the next question from the audience, perhaps I'll interject a question. During your opening statements, each of you talked about political diversity or the lack of political diversity on the Supreme Court. I'd like to ask a question about diversity in a different respect, ethnic and racial diversity, both on the Supreme Court, or the lack of diversity on the Supreme Court, and more broadly, the lack of adequate diversity in the profession. Beginning, I guess, first with Judge Sikora, would you comment about what any of us can do, lawyers, judges, other interested community people, what can we do to enhance diversity in the profession and more particularly in our judiciary?
Well, I think we've seen over the past many years, there's certainly been progress made, especially by women in the profession and on the bench. The representation of minorities on the bench, I think, is certainly lagging, particularly in urban counties around the states. And I think probably the best way to address that is really the way that women broke through, and as the number of women going to law school increased, the number of women joining the profession increased, the number of women who assumed major responsibility in the law firms increased, and then naturally went on to the bench. We need to do the same with minorities. We need the law schools to encourage participation. We need law firms to reach out to minorities. And I think the natural progression will be that more minorities will serve on the bench. I said before, too, I think there is one glaring lack, particularly on the Supreme Court, and that's people using wheelchairs. And I would certainly like to change that on November 4th.
Very good. Justice Stratton, please.
I believe that women have made a great deal of progress. When I started, I was the first woman judge. I was the first in all my law firms. I was the first in practically everything. However, if our two opponents are successful, that will go backwards because we will then have 6 males and 1 female on the bench. So I would urge you to keep the women on the bench for that reason. But I think we still lag way behind in the African American diversity and other ethnic groups. When I was a trial judge, I participated in the Bar Association Minority Clerkship Program. I was on the Board of Governors, and we tried to encourage law firms to hire minority clerks under a special program to give them a little bit of an edge. I mentored African American women through our OSU law student program, and met with them regularly and tried to help give them opportunities. I regularly try to appoint African Americans to the boards and commissions and other ethnic groups to our boards and commissions, because by giving them those opportunities, we can put them in the mainstream and hopefully encourage them to seek a life of public service in the judiciary. So we definitely need to keep working on those efforts, and I continue to do so as a justice.
Thank you. Next question from the audience, please.
There's an assumption in my question that I think most people share, and that it's important to have an informed electorate. This question is for both candidates. Justice Stratton, you mentioned that the race for Supreme Court is way down the totem pole. That's true. And most voters do not know who the candidates are for Supreme Court or don't know much about them. If that is also true, then why is it that we should vote for candidates for the Supreme Court? I guess also implicit in that is a question, should we? I mean, maybe we shouldn't. So that's the point.
I'm a firm believer that we still should elect our justices. I know the Chief Justice and I differ on this, but to me, an appointed system is an election still, but only a very few people vote, and almost all of the political considerations still are at play, but with a different background. When you have an elected system, everybody has the right to have input. I call it the world's longest job interview. I have done an interview like this. My opponent and I have been at numerous hearings or speeches or endorsements. All of that information now is available on the internet. You can find out a lot. It's just a matter of whether people are interested or not. So I still believe it's important that people know who their justices are, because when they're appointed, you know almost nothing about them. But I think that the race this year is down on the totem pole because there's a lack of excitement because everybody seems pretty happy with the Supreme Court. That's what I hear over and over and over. 6 years ago, nobody was happy with the Supreme Court. I was part of a minority. This room was packed with lawyers who were very interested, but they're pretty happy now, and so there's not a lot of interest. So I suppose that's a good thing. It's hard to get elected like that, but it's a good thing for the judiciary to have that reputation.
Judge Sikora?
I agree that we should elect our judges. I am a Jeffersonian Democrat. I think if we're smart enough to elect our presidents and our state legislators and our mayors and governors, we're smart enough to elect our judges. But I agree that we need to somehow spark interest. There's certainly a lot of information out there for people if they want to become educated. We have had probably 6 or 8 joint interviews before editorial boards. The law, the bar associations have evaluated the candidates. There's a lot of profiles out there, particularly with the internet. There's an awful lot of information that if people want to know about their candidates, the information is there. Thomas Jefferson also said we get the government that we deserve, and if people don't pay attention enough to get information, get informed about the candidates, then sometimes perhaps they don't get the best that they deserve. And I would disagree with Justice Stratton. If she feels that everybody's real happy with the Supreme Court, I would invite her to join me on the campaign trail, because I hear quite the opposite quite often.
Okay, before we take a question from the audience, if I could ask then a kind of a follow-up question related to that issue. And Justice Stratton, you touched on this in your opening statement, or you remarked about 2 years ago there was a New York Times article, and it published a study about the correlation between the voting records of justices on the Ohio Supreme Court and campaign contributions. And you indicated that yours was either the lowest or among the lowest of the sitting justices at a 55% correlation. What that means and what the article disclosed was that there were many justices who had a much higher number, some well into the 80s or beyond. That is a correlation between their campaign contributions and their voting records. The article suggested, and there was a lot of public comment thereafter, that the article raised questions about whether Ohio Supreme Court justices were being improperly influenced by those contributions. And even if there wasn't actual improper influence, at least raised the specter of an appearance of impropriety or lack of fairness. Both of you have indicated, though, that we should still have judicial elections. Assuming that in light of these concerns, but we're going to still have judicial elections, if we retain the current system, would you support requiring a justice to recuse himself or herself in any case in which one of the lawyers or one of the parties involved in that case had made a campaign contribution to that justice? And Justice Stratton, you go first.
I would not, because our system of electing judges requires judges to be elected. And if you are elected, it means that you have to raise money to get your name out. Our populace has twice rejected any other form of government. They've clearly spoken that they want the justices to be elected. If we were to go to a system where the justices had to recuse anytime there was a contribution, we would have an entire bench of visiting judges, whether it's Democrat, Republican, no matter what group supported you. You would have a bench that you did not elect to represent you. And that cannot work in our system. So what we have is campaign contribution limits. Both my opponents and I are limited in what we can accept: $5,000 or $5,500 from any PACs, $3,000 from any individual. When you raise money, that is all they can give. That very seriously limits any potential influence. And if I have more time later, I'll address the New York Times article because I have strong feelings about it.
Thank you. Judge Sikora?
We have a problem with the system. A League of Women Voters study just a couple of years ago suggested that 84% of the people feel that money influences decisions. Whether it does or doesn't, the fact that so many people feel that it's terrible, and we need to address that. Unfortunately, things that have happened over the past several years only reinforce that. I mentioned before that 5 of the justices had to recuse from hearing Tom Noe's cases because of contributions he had made. And just recently, a couple of asbestos decisions came down that severely limited the rights of people to be able to sue for injuries sustained. There is an independent group out there supporting Justice Stratton and Justice O'Connor that has raised nearly $1 million. 93% of their money came from people who were interested in those asbestos suits. I have made a proposal. We need transparency, and if we had a situation where every time somebody filed an appeal with the Supreme Court, they had to list the money that they had contributed to either the justices on the court or to independent groups supporting their election, I think that would go a long way towards making people feel more comfortable with the decisions.